In this video, I want to discuss how to become a permanent resident of the United States if you or the intending immigrant came into the country legally or came in legally but overstayed and are now married to a U.S. citizen or a permanent resident of the United States. There's a three-part process to have success in this area of the law. This area of the law came about in the year 2013 under the Barack Obama administration, and it's a new waiver called a provisional waiver or a provisional waiver of unlawful presence. The application we use for this process is called an I-601A. So if anybody's interested in exploring a little bit, we'll have a link in the description to the I-601A. They can do some reading and look around the internet a little bit and learn more about this process. And essentially what it's supposed to do is keep families together while the whole process of obtaining a waiver for certain immigration infractions takes place, and it takes quite a bit of time. There's 3 steps in this process like I talked about. The first step in the process is a family petition. The legal permanent resident or U.S. citizen spouse will file an application called an I-130 with immigration with USCIS, and in this petition they're trying to prove that there's a valid marriage in place. So while they wait for immigration to approve that valid marriage, they can start looking at the different steps in the future, but it's important to send enough information about their marriage to show that this is a valid, legitimate marriage based on love, not based on paperwork, and send that to immigration and let them run their process. While they're running that process, the couple can then look at the next step, step number 2, which is asking for the waiver itself. They already know that there's some situation in the immigration history that's going to cause them to need the waiver. Specifically what this is if the person's been in the United States for more than 365 days with no documentation, eventually when they leave the United States as part of this process to go to a consulate or an embassy in their home country, in the moment they leave the United States, they'll have a 10-year bar. They can't come back to the United States or even apply to come back to the United States for at least 10 years because they've stayed inside of the United States for more than 365 days without documentation. So that's the problem. But what happens is this waiver can get rid of the problem even before they leave to the consulate or to the embassy, and that's why we need to look at it. The application, again, that we filed is an I-601A application, and this is filed with USCIS. The application itself is pretty short, but what it is we have to show that the intending immigrant has family members who are going to suffer what's called extreme hardship if they're not allowed to be approved for this waiver. If they're forced to remain outside the United States, these certain family members will suffer in what they call an extreme level. Okay, so the qualifying family members, the types of family members you can use to try to prove hardship to the intending immigrant are either the spouse that would be a resident or a citizen, or parents who are residents and citizens. For this particular process, they still can't use children as a basis to prove that some U.S. citizen or permanent resident family member would suffer greatly if they're not here. So it's spouses or parents, right? So what we do is determine which group of people we're going to use. Is it going to be a parent? Is it going to be a spouse? And then when we determine who that is, what we'll start to do is ask that person to start bringing us documents that would show the hardship, right? It could be financial hardship, bankruptcies, unable to keep a job, the instability, but the intending immigrant is the person that helps financially. It could be mental health. There could be depression and those types of issues that the person is suffering, and now if the intending immigrant is outside the United States, they're going to suffer even greater. It could also be maybe physical, something, a sickness or an illness or operations, and it could be a combination of anything. Everybody's different, but I've noticed over the years, and I've been doing this since this was announced in the Obama administration, that you can almost always find a particular circumstance in somebody's life that would provide a good argument for hardship, argument for this waiver. When we file this waiver, we have to file it with evidence that the step number 1 had been approved. So the family petition had been approved, and now we're in step number 2, and we're sending in this waiver application to USCIS. This part can take a long time. It can take little over 2 years, maybe up to 3 years, depending. It's important to go to uscis.gov and look under processing times and under the specific application to get a good estimate about how long this application takes, and it always changes. But it takes quite a long time. If and when it's approved, then we move to step number 3, which is working through the consulate or the embassy in the immigrant's home country, right? And so that step is interesting because it moves over to the State Department. We file an application known as the DS-260, requesting or petitioning for an immigrant visa, and also an I-864, which would be a sponsor application, along with another set of applications and documents that immigration is going to request for that interview. And then you get into a queue or in a line and wait for an interview at that particular consulate or embassy. When the immigrant finally gets their interview notice at the consulate or at the embassy, they're eventually going to have to leave the United States to attend that meeting. And that's a part that a lot of immigrants are very scared about. But it's important to remember that we wouldn't have even gotten to that point if we didn't already get a waiver forgiving the fact that they were in the country illegally, so they can leave with confidence and attend that interview. Once they leave the country, there's a couple little jobs they have to do before they go to the interview. First one is they have to go to the local police in their country of origin and get evidence that they don't have past criminal history that would disqualify them from that country, right? And secondly, they have to do a medical exam, and so there's lists of doctors that work directly with the embassy in these types of applications, and they have to get a physical exam and make sure that everything's good so they can go to their meeting at the consulate or at the embassy. At that meeting, if everything goes well, they'll leave their valid passport from their country of origin, and then they'll go maybe stay with family or a vacation or whatever for a few days. They have to leave an address where immigration can put the visa into their passport and send their passport to that address. And once they get it again, then they can return to the United States. After they come back to the United States, they register on a website for immigration, and then they can receive a green card in the mail. Now, this whole process can take quite a long time. Right now, we're telling clients perhaps between 2.5 and 3 years. And again, it all depends on processing times for immigration. They can get faster, they can go slower, depending on the country, depending on the backlog that immigration has. But in general, you should plan for this to take a long amount of time. The good thing that the Obama administration did with this was allow it to happen, or most of it to happen, all the way up until the last step, while the person waits inside the United States and is with their families. Previous to 2013, people requesting this type of waiver had to leave the country and do all of that waiting outside of the country, and that really split a lot of families apart and really dissuaded immigrants from even starting the process. But with this new process, anytime they leave the country might be 2-3 weeks, 1 week, depending, and they don't have to wait for months or years outside of the country. So it's a process that was greatly improved on during the Obama administration. Like I said, I've been working on this particular type of application since the day that it came about. I've seen lots of different scenarios, lots of different circumstances, all the pitfalls that can come up, and I strongly encourage people who are applying for this process to work with an attorney. Could be myself, could be any attorney across the country who has experience with this type of thing, because there are a lot of pitfalls and things that can be dangerous for an immigrant in this process. We're happy to help out. We have links in the description below about how to contact us. A lot of our content will be in Spanish, but if you call, we can also set you up an interview and a consultation with an attorney in English and get you on the right path so that your immigrant spouse who is in the country legally can obtain a residency in the United States.